This is Andrea Kane, and I'm here with you for HIT 421. Legal aspects, release of information, HIPAA, all that good stuff. We are here on week 10. This is the second lecture video for this week, and it's on chapter 15. Chapter 15 is actually utilized not only in week 10, but also week 11, 12, 13. Yes, 11, 12, and 13. So this lecture video will be reposted in weeks 11, 12, and 13, so it's available for that, not just in week 10. If you are looking at your course syllabus, you'll see that we are covering unit objectives 9.7.1 through 9.7.26, and that will be the same for the next several weeks as well. If you would like to follow along in your textbook, I am on page 339. 339. So if you want to flip there, that would be great. This is going to be a bit of a long one because there are 62 slides to this PowerPoint, and some of them I'm sure will require a wee bit of explanation. But I will try and move them through them as quickly as I possibly can. So they want us to start out by reviewing terms, access, use, and disclosure, looking at the HIPAA definitions. So access is the right of an individual to inspect and obtain a copy of his or her own health information that is contained in a designated record set. Use means sharing, employment, application, utilization, examination, or analysis of individually identifiable health information within an entity that maintains such information. Disclosure means release, transfer, provision of, access to, or divulging in any other manner of information outside the entity holding the information. Please make sure that you are very familiar with these three terms because you will need to know this, not only for now, but eventually for Chapter 15's quiz, as well as eventually for your exam, your RHIT exam. So this is a very important slide. Release of information differs from disclosure because that release of information, although it's used interchangeably with disclosure, really refers to providing access to PHI to an individual or entity that's authorized to receive or review the information. So release of information is sort of a function. Disclosure is what takes place, but release of information is what is the means by which the information is disclosed, so to speak. Going back to this, we've covered this multiple times, but hey, what's one more time? Who owns the health medical record? It is the business. So for us, it is the healthcare organization or the healthcare provider. That's who owns the health medical record, the business owner. And what do they own? They own the record in itself, its contents, its pages, its data, all of that. But the information that's contained within the record, that would be your primary data source information. That information actually belongs to the patient. So primary source information or source data or information, if you look back, is always medical record. It's based on the provision of care. Secondary data pulls information from the health record and makes it available in sort of a database, or it's pulled to be used for a different way. And it may include some other non-primary data source information. So again, they ask the question, what right does the patient have to their primary and secondary data? They don't own it, but they have the right to have a copy of it, to request that it be amended, and all those other things we've gone through with HIPAA, such as an accounting of disclosures and the ability to have a copy, see their record, all those types of things. So we've talked through HIPAA, both privacy and security. We know that individuals have rights to access, use, and disclose his or her protected health information, the PHI. There are authorization and accounting of disclosure requirements. We've walked through some of those. Patients can opt in or opt out of sharing information with health information exchanges. Typically, when they're completing the registration paperwork, they have to opt out, otherwise they've opted in. Or there's a statement there that says that when they sign, they've opted in. Or they can click a box or check a box and say, I'm opting out. Most state regulations provide patients the right to access their health information and protect patient confidentiality. They do now. They didn't always before HIPAA, but they do now. So who can access PHI? If you are a competent adult, age of majority, which is 18 and above, if you are an individual's authorized personal representative, like their healthcare power of attorney, an individual who, and so that's like the individual that holds persons, they can access health information. Now, I do want to point out on this screen, I disagree with them saying durable power of attorney, because power of attorney is not healthcare decision making. Power of attorney is financial, business related, those types of things. So it would have to be someone who had a durable power of attorney for healthcare decisions. So you might want to make a note of that. So a competent adult, again. There is the Uniform Healthcare Decision Act that also permits a surrogate or next of kin. There is now an established decision-making priority tree. So the first line is the competent adult. If they are not available or are not competent or are not conscious, it goes to the spouse. Then it goes to adult child, and typically it's the oldest down to the youngest. Then parent, then adult sibling, and again, oldest to youngest. Adult non-relative that's familiar with the patient, or a court-appointed individual. An incompetent adult is over the age of majority, but they're incapacitated. And in order to be deemed incompetent, the court is the one who has to legally deem someone so. And then they appoint a legal guardian, who could be the spouse, parent, sibling, agent, attorney, or surrogate. Competent adults or legal guardians of incompetent adults have the right to request, receive, examine, copy, and authorize disclosure and release of PHI. Excuse me. I don't know what's wrong with my voice today. Minors. These are individuals that are under the age of 18. They're not legally emancipated. Legally emancipated minors are just like competent adults. So you've got to pull that emancipation out of it. We're talking just minors who are not legally emancipated. They require parental authorization except in very specific cases. And some of those are listed for you here, including abortion, mental health, substance abuse treatment, sexually transmitted infections, those types of things. In those cases, they can authorize access, use, and disclosure of their own health information. Otherwise, they have to be legally emancipated by the court in order to be considered able to do that. Parental authorization is typically required. It can be married biological parents, separated or divorced biological parents, adoptive parents, foster parents, grandparents, legal guardians, or a relative with guardianship while parent is overseas or in service. One of the things that you may stumble into if you go into the release of information field within HIM is cases where there's been remarriages and a parent who is not a biological parent but who is a step parent may need to get the records for school or some other purpose, and they're not permitted to because they don't fall into this parental authorization recognized by law. Each state, of course, defines the parent who can sign, so that may have changed for some states, but just know that that's something you're going to want to check when you're talking authorization of a minor. Parental authorization, again, is not required if someone is an emancipated minor. This means they're under the age of 18 and are self-supporting, and their parents have surrendered their rights of custody, care, and support. This includes minors who are married or previously married, a minor who is in the military, a minor who is parent of a child, a minor who reaches the age of majority while under treatment, and a minor that's treated for drug or alcohol dependency, mental health, STDs or STIs, HIV, AIDS, contraception, and abortion. And then, of course, some of this may depend upon state law. When it comes to non-custodial parent, and I guess I jumped ahead with that, sorry about that, but when it comes to non-custodial parent or others, a parent who does not have legal custody of the child does not have the right to access that information. You have to be legally endowed, legally given parental rights, which allow access unless stated otherwise by the law. So they give us a scenario here that the father seeks medical records of his child. It is learned that the father has visitation rights with the child, but is the non-custodial parent. Should the requested records be given to him? The answer is no. If they're a non-custodial parent or do not have legal custody of his child, you are not supposed to release that information to them. They would have to go to the custodial parent to obtain a copy of the information. So what is best practice regardless of a person's age or competence? Well, with minors, in the case of a non-custodial parent, you need to seek authorization whenever possible. If you're talking about an emancipated minor, you need to verify the court order or other proof that the minor is emancipated. And the way you can do that is if they bring it in, you can scan it and put it into the record, and that way it will always be there. And with EHRs, this is very easy to do. In fact, you can set it up so that it is not a visit level document, but sort of a chart or individual level document so that it follows the individual regardless of the stay, regardless of what visit they're having. An incompetent adult, of course, you need to require legal documentation that the incompetent adult's legal position has been affirmed by the court and that the patient's obviously unable to sign the authorization, and then verify the documentation of the person's representative to validate that they have the authority to access or authorize disclosure of the incompetent adult's PHI. Who can access health information? Can employers, can employees, and other workforce members? There are some times that by the nature of the job or work relationship, some access may occur. One of the things that I've always encouraged the people who worked with me is that if they recognized a name of a neighbor, a family member, themselves or anything like that, that they would get one of us who was not them or who didn't know the person in question to code the chart or scan it in or do whatever to protect them from allegations of inappropriate access. So that's just something to think about, that as you're processing things in an HIM position, that if you run across something that is someone you know, if at all possible, have someone else handle that. It protects you, and it also keeps you from potentially committing a breach or accessing information that you don't have, that you really shouldn't be accessing, even though it's part of your job. So there are specific rules as to whom workforce may access, who has legitimate right. Most organizations have this in their information management plan, in their IT policies and procedures, that type of thing. but you want to refer back to HIPAA and state regulations if there are any questions. So what are some types of super sensitive health information that has sort of a higher threshold to meet in order to obtain a copy? Meaning that it has to be specifically authorized, it has to be specifically requested and specifically authorized. Well, it absolutely includes behavioral health information or mental health, substance abuse records, both alcohol and drug, HIV records, genetic information, and adoption information. In all of those cases, if someone is trying to obtain a copy of that information, a specific authorization will be required, and of course validated that they have the right to this information. And going back here, there are certain times, for instance, with behavioral health information, that a doctor could keep it from the patient if they feared it would set the patient off, or cause the patient to become suicidal, that sort of thing. All right, so in general, anything that's mental health related needs to be kept confidential. So when you look at Iowa state law, looks to see what are the protections and exceptions that are referenced. Do that with whatever state you're going to be practicing HIM in. Requests by patients have been historically denied because providers have been concerned that if the patient reads their medical record, it may worsen their mental illness, or it may cause an explosion of emotion or temper, or they may be tempted to harm themselves or someone else in that way. So typically, if you're a patient and you want a copy of your behavioral health records, there are a few more hoops to jump through. Obviously, today facility policies may still provide for asking the physician first. A lot of times that's the way they were handled in the past, that you would go to the physician that was the attending physician for that behavioral health patient and obtain permission before releasing any information. And then some states specifically grant right of access to the patient, which is then consistent with the HIPAA privacy rule. In terms of requests by others for behavioral health records, it goes back to your state law, state statute on right of access. Some factors that you want to consider when you're setting up rules around this with behavioral health and you're looking to release that information, make sure the authorization form is specific, that it has that statement in there that that it includes or excludes behavioral health information, so that the patient clearly can check, yes, I want it, I authorize it for release, or no, I don't. The identity of mental health patients, their identity is often protected by state statute, and so there are times when how it's released and who it's released and all of that may be prohibited by state statute. So you really need to know your state laws pretty well. And then the state statute has to comply with HIPAA, and you use whichever one is the more stringent of the two. Whichever one has the most demanding requirements. Duty to warn, and I think we studied this a little bit earlier, that there is a duty to warn under certain circumstances. Some state laws permit or even compel psychologists and psychiatrists to use their discretion to warn intended victims of potential harm without the patient's authorization. Typically, they'll go to the police if it's something like a crime or whatnot. And I believe you did study Tarasoff versus the Regents of the University of California. Hopefully that rings some bells. Moving on to substance abuse records, these are very similar to behavioral health records. Again, they're governed by federal law, and it lists those here for you. It protects the confidentiality of patients seeking substance abuse treatment. Any federally assisted drug and alcohol programs, and this is a broad definition, are under that federal law, including programs that are providing diagnosis, treatment, or referral for a drug or alcohol and/or alcohol abuse. So any program that is involved in that is also covered under this. Let's see, moving on. Federal law protects the identity of substance abuse patients, not just their clinical information. Their authorization form needs to be very clear and specify release of substance abuse information is being authorized by the patient. And it has to have certain items on the form to be valid, whether that form is paper or electronic. If a minor can consent to treatment per state law, then the minor can authorize release of the records. There are limited exceptions to the authorization requirement for substance abuse records. This is medical emergency, scientific research, audits, program evaluation, court order, and suspected child abuse, to name a few. Whenever federal and state law conflict, the most restrictive, the most stringent, the most demanding, the most protective of patient confidentiality always wins. So that's why you have to know your state law. And here in Northeast Iowa, we are close to Wisconsin, close to Minnesota. Even as you get toward the Quad Cities area, you're close to Illinois. So if those are the areas where you work, you'd want to make sure you knew Illinois, Wisconsin, Minnesota, state statutes on these topics. Since you would be dealing with patients that seek care there and are from there. And there are some efforts going on to update the regulations. So hopefully we'll see that come out in the next couple of years to bring us out of the paper world and more into the electronic world when it comes to substance abuse. HIV/AIDS. This is a tough one because you have competing interests. You have a patient that has a need for heightened sensitivity and compassion. You have healthcare providers who need to protect themselves while also providing care. You have the government, which needs access for research and to monitor the spread of HIV/AIDS. And then you have third parties who may be exposed to the disease and need to be aware that which status they have and a few details that go along with that. The general rule is that HIV/AIDS information is to be kept super confidential, like behavioral health and substance abuse information. HIV/AIDS, you're not supposed to disclose that unless it is very specifically demanded by the patient with a patient authorization. So a typical state law will provide protections and then provide exceptions. And wrongful disclosure can lead to civil penalties, fines, essentially. And then the example they give us here is of Ohio. If we were close to Ohio, this would be much more helpful, but it gives us an example. Ohio law protects the identity of individuals who receive an HIV test. And the results of that HIV test are also protected. So that they can't be identified, they can't go back and identify the individual, and that the identity of the individual who is diagnosed with AIDS or AIDS-related condition, that's also protected. So HIV status, do you disclose it or not? Well, CDC guidelines say that if the HIV status is known before treatment and the treatment will be invasive or exposure prone, then yes, you need to disclose it. if you learn that the person is HIV positive after the treatment, you have to determine on a case-by-case basis whether that will be disclosed, how it would be disclosed, who it will be disclosed to. HIV status acquired through blood transfusion. The courts have been split. Some have said yes, some have said no. So that one is kind of a toss-up. Could go either way. Specific HIV policies and procedures are key to proper protection and disclosure, and I would argue that that includes also not just HIV/AIDS, but mental health, behavioral health, substance abuse, all of those. Genetic information is another one that has received a lot more protections over time, because there's the potential for powerful use of genetic information. So they're trying to protect it. So that one, again, you definitely need authorization for. It needs to be specific and spelled out and all of that. There's also potential problems with misuse of genetic information. Insurers can deny, limit, or cancel health insurance. They can raise premiums, and employers may discriminate against individuals in a workplace. In 2008, the Genetic Information Non-Discrimination Act was brought into being, and this prohibits discrimination by health insurers and employers based on genetic information. It's been in place since December 7th of 2009, and focuses on genetic non-discrimination in health insurance, and states that health plans may not use genetic information to make eligibility, coverage, underwriting, or premium setting decisions, which I think as federal law is a great idea. So GINA, this law of genetic information, does modify the HIPAA privacy rule a bit, because at the end of the day, genetic information is PHI, it is health information, and prohibits the use and disclosure of genetic information by covered health plans, except for they're prohibited. They can't use it or disclose it when there's underwriting purposes going on. There are a couple of exceptions. Health insurers may request genetic information in the case that the coverage of a particular claim would only be appropriate if there is a known genetic risk. And then, so that's the first one. That's the first exception. The second one is when working in collaboration with external research entities, health insurers may request, but not require in writing, that an individual undergo a genetic test. The individual may do so voluntarily, but refuse to participate. But if they refuse to participate, it will have no negative effect on their premium or enrollment status. The collected genetic information will be used for research purposes only and not for underwriting decisions, which is a great relief, I think, to people who do have genetic information out and want to keep it protected. So another aspect of this law is that it prohibits the use of genetic information in making employment decisions. It restricts employers and other entities in joint labor management training and apprenticeship programs, referred to as covered entities, from requesting, requiring, or purchasing genetic information, and strictly limits the disclosure of genetic information. There are some state genetic laws if you look here, statutory or regulatory provisions that safeguard genetic information and prohibit discrimination in employment and insurance benefits based on genetic information and mandatory genetic testing for employment and insurance purposes. So some state genetic laws basically say that it can't be used for employment or insurance benefits. Then another aspect to this is the degree of protection provided by the states varies. Some state provisions are less protective than the federal law, some are more protective. All entities have to, at a minimum, comply with the applicable requirements as well as the more protective state laws. So the National Conference of State Legislatures, NCSL, maintains information about current issues facing states, including those surrounding genetic privacy laws. Current state genetic privacy laws are summarized in a table on the NCSL website if you would like more information. The Precision Medicine Initiative 2016. Are you familiar with this? Their goal is to speed up patient-centered biomedical discoveries using genetic information. So they set privacy protections in place and ways for patients to participate but still retain control over the use of their information. And I'm looking for what page this is on. I thought it was on or around page 355, 356. Well, I'm sure we'll run across it at some point, but just so you know, it should be somewhere around there. It does set privacy protections in place and ways for patients to participate but still retain control over the use of their information. Adoption. Adoption has been an interesting aspect to all of this over time. Most adoption records, if it's not an open adoption, are sealed, and it's next to impossible to get them opened. Adoption is the legal status in which the parental rights and responsibilities of one set of parents are legally terminated, excuse me, and a new parental relationship is established by law. Parties to an adoption are adopted individual, who is known as the adoptee, biological, natural, or birth parents, and then the adoptive parents. The rights of each must be considered in light of access to health information, because one of the things that happened in the past by sealing those records is individuals who were adopted had no idea of their family history, of cancers or diseases that ran in their family or anything like that. It was all sealed. But over time, that has been really changing because they want individuals who are adopted to take with them some family medical history, so that in the future they have that. Adoption records include public and non-public documents, the original sealed birth certificate, court documents relating to the adoption process, and the records of the adoption agency and/or attorneys involved in the adoption. So it includes all of those. And notice again, not all of those are public. Many of them are non-public, private. Adoption records are considered confidential by most state laws. However, most states require that the adoptive parents receive specific health information about the adoptee. I have been involved in birth certificates throughout my career, and there have been times where a mom has put her baby up for adoption, and the adoptive parents, I've seen it go both ways. It's been an open adoption with the adoptive parents there, and I've seen it be a closed one where the mom leaves the hospital, the baby's there at the hospital, the adoptive parents come in and get the baby, and have actually had to redact paper records. And this has been a few years, but we've also somewhat done it with electronic records too. But anyway, where you take off all the identifying information so that you can make a copy of it for the adoptive parents so that they have health information about the baby being adopted. Um, but it has to be very carefully done and well reviewed before you release it, because you can't have anything that identifies that birth mother on there or the parents whose rights are being terminated. Medical necessity generally satisfies the good cause requirement to release adoption records that contain medical information. But again, when that happens, someone is going to go through and they're going to black out any information that would identify the birth parents. So the biological parents, they've relinquished their parental rights and refer requests to adoption agencies. Adoptive parents may inspect the minor adoptee's medical records after all identifying information regarding biological parents have been redacted. Just said that, sorry. Again, I got ahead of myself. After the age of majority, the right belongs solely to the adoptee to have information about their medical records. But again, the information about biological parents is removed. So someone who was adopted as a child, any age as a child, baby, all the way up to age 16, 18, they can go back and get a copy of their records after they turn 18. But the copy that they get will be no different than what was given to the adoptive parents, because the biological parents' information will have had to be removed. Minor adoptees that are trying to trace their biological parents are always referred back to the adoption agency. And if the birth parents did not put on there that they are willing to be contacted, it's often a dead end for minor adoptees to trace their biological parent or parents. So let's talk about active records of currently hospitalized or ambulatory care patients, because this has changed up a bit over the years. A currently hospitalized patient, i.e. an inpatient, or a patient currently being seen in a clinic setting, outpatient, or their personal representative may access, inspect, obtain a copy of, or disclose PHI from the patient's record. Active record is a term used to denote the health records of individuals who are currently hospitalized to inpatients or receiving care as outpatients. If an active inpatient or outpatient wishes to access, copy, or disclose his or her PHI, the healthcare provider should follow the same policies and procedures that are in place for allowing the access, copying, and disclosure of PHI for patients that are not currently hospitalized or being treated as an outpatient. Why did they do this? Why did they make this rule? Well, when I first started out in HIM, the rule was that if someone was currently hospitalized, they couldn't have a copy of their record until their record was complete. And because a record wasn't complete until 30 days after discharge, you could hold up providing a copy until that time. And so that's why they've said it doesn't matter if you're in the hospital or if you're finishing up outpatient treatment. If you want to be able to see your record, obtain a copy of it, those types of things, you can do that. The hospital or healthcare organization has to provide it. All right, moving on to deceased patients. When someone deceases, obviously their own individual access goes away. And then you get into who has the right to access or authorize access of the deceased person's PHI. This is usually determined by state law. So again, you've got to know your state laws. HIPAA says an individual has the same privacy rights in death as they did in life, but leaves it up to the states in terms of who qualifies as the deceased person's legal representative for access, use, and disclosure purposes. So HIPAA says, yeah, you got to give them the same privacy rights in death as you did in life, but it's up to the states to determine who's calling the shots on the PHI after someone dies. Typically, it's the executor of the estate. If there's a legal executor or administrator of the estate, they have first rights to access, use, or disclose the deceased person's PHI or records. If there is no executor, then typically what happens next is they look at the next of kin. And remember, I'm going to go backwards here. Remember how we were looking at that earlier? Let me make sure I don't go past it. Hopefully it'll be back here. Just, I know. Yes, this. Oh, no, that's minor. Sorry. Got excited there. This decision-making priority from the UHCDA, the Uniform Healthcare Decision Act. So if you have the executor of the estate or the estate's administrator, they get their first in terms of determining access, use, and disclosure of a deceased person's PHI. If there is no executor or administrator of the estate, then they start working their way down this decision-making priority. So then the spouse would, then the oldest adult child would, and it goes on from there. So just wanted to bring that back to you because when you're talking deceased persons, you start with that executor or administrator, and if that doesn't work, then you use the next of kin information. Okay, so we covered that. Sometimes states do require that these next of kin individuals become the deceased person's official personal representative, and this happens by going through probate, where the judge issues a court order or the will is probated, and as part of that it will identify the individual who now has this legal right on behalf of the deceased person. HITECH made changes to HIPAA, and some of the changes that they made was saying that 50 years following someone's death, they no longer have the protections of PHI on their record. But since most states don't keep medical records for 50 years, most of us are lucky if our state keeps our records for 7 years if we're an adult. This probably will never ever be in play. HITECH also changed HIPAA's privacy rule as it relates to deceased patients by saying that covered entities can disclose the deceased's record to family members and others that are involved in the patient's care or in getting payment of care, unless doing so would be inconsistent with any known preference of the patient. So if the patient said, I don't want my estranged family member to have a copy of my records while they were living, after they died, the covered entity would have to respect that. Of course, federal rules don't always clearly lay out exactly how everything's going to go. So there's still some gray areas on how the records should, how and who and all of that, how they should be released. It's up to the covered entity to have a reasonable assurance that the person requesting the record has a legitimate right to access it. And that's true of everything. You always have to make sure a reasonable assurance that the person that you're providing the information to really does have a legitimate right to access it. And especially when you're dealing with deceased patients, patient records, and it could be that there's multiple people in the family and they're arguing and that type of situation. Best practice is to suggest the healthcare providers require requesters to show proof of relationship to the decedent or present present court-authorized documentation showing authority to access the deceased individual's PHI. And that's what I did back when I was involved with this, is someone could come in and they could say my father died or my uncle died or my brother died, anything like that, but we required documentation, and if they didn't have it, we encouraged them to go contact a lawyer and come back to us when they had the paperwork to prove it. When it comes to disclosure of information for autopsies, there are also some rules that go along with that. Autopsies are performed to determine cause of death, and this can be objectionable to some religions and cultures. A consent to autopsy is required except where autopsy is needed to determine the cause of death for public policy purposes. Well, this is sort of the situation with a medical examiner. If it's for if it's like a medical examiner case, then typically an autopsy consent is not required. Otherwise, if someone dies in the hospital and the family wants an autopsy, there has to be a consent form completed. The HIPAA privacy rule allows PHI to be released without patient authorization to a medical examiner or coroner for purposes of identifying a deceased person, determining their cause of death, and other authorized purposes. And I guess that's what I said in a roundabout way. If the death is not a medical examiner or coroner's case, then the surviving spouse or descendants of the deceased can still authorize the autopsy. But a healthcare organization should definitely require that an authorization form be completed and retained in the health record for evidentiary purposes. So moving on to open records, public records, or freedom of information laws, also called sunshine laws. These are at both the state and federal levels. There are laws that demand that information be released, and they provide for scrutiny of records created by public employees. So this primarily applies to public hospitals that may be owned by the state or owned by the county, things like that. This is on page 360 in your textbook, if you're wondering. And I'm going to leave you to read through that. It's got some good information in there. I'm going to move on to OSHA, and this is on page 361. So when it comes to employee health or occupational safety, or OSHA, these records are kept on employees as part of employment and may contain any and all information related to items such as medical tests, drug tests, examinations, physical abilities, immunizations, screenings, biohazardous exposure, and physical limitations. There are quite a few federal and state regulations that govern health records when it comes to employee health or occupational safety, that type of thing. Employees have the right to access results of drug testing as well as their employee health record. So they have to be given access within 15 days of request. Some state laws are stricter and preempt the OSHA law. So it's, again, whichever rule is stricter, whether it's OSHA or the state. Employees should be told in advance what health records are maintained on them and notified of any release of such records. Occupational health providers who are covered entities must abide by HIPAA rules and obtain patient authorization or make reasonable efforts to do so before disclosing health information about an employee or from their health record. And then there is the Patriot Act of 2001. And this came right after 9/11. And this was enacted to deter and punish terrorist acts in the U.S. and around the world and to enhance law enforcement investigations. It gives the director of the FBI or his or her designee the right to apply for a production order through the court system to produce tangible items such as documents and records. It provides sanctions for any unauthorized disclosures of the information obtained by others that is not involved in the investigation. And a healthcare provider who in good faith provides this PHI that's requested under the order would not be held liable for releasing the information because it's part of federal law. And then it was followed by the Homeland Security Act of 2002. And again, it's looking at terrorist attacks in the U.S. And it gives the Secretary of Homeland Security authority to access information that includes PHI without the authorization of the patient or personal representative. So moving on to syndromic surveillance. This is where you have systematic gathering and analysis of pre-diagnostic health data to rapidly detect clusters of symptoms and health complaints that might indicate an infectious disease outbreak or other public health threat. There are mandated federal and state public health reporting laws, and the goal is to provide public health officials with necessary information to help detect bioterrorism threats and sudden outbreaks of diseases. Having been through COVID, I think we're all familiar with federal and state public health reporting when it comes to this. They use what's called the electronic surveillance system for the early and notification of community-based epidemics. Consumer reporting agencies. These are companies that regularly assemble or evaluate consumer information for the purpose of producing reports. So an example they give us are the credit information and then health information. In 2003, FACTA, the Fair and Accurate Credit Transactions Act, was put into place that provides protection to consumers against misuse of their PHI, and it amended the Fair Credit Reporting Act related to obtaining and using medical or health information in connection with credit eligibility determination. What it means is it prohibits the creditor from obtaining and using PHI to decide the consumer's credit eligibility. The creditor can obtain and use financial information related to medical debts, expenses, or income. But when it comes to PHI, the consumer or the patient has to authorize the consumer reporting agency then to have a copy of that medical information or share it with employers for employment or insurance purposes. Other access request disclosure situations. Well, let's talk about lab test results, and this is under the CLIA rules. Labs are only to disclose test results or reports to an authorized person who ordered the test, meaning the provider that placed the order, unless state law states otherwise. So for instance, labs can't just release results willy-nilly. They have to go back to the provider who ordered them. The individual who is the subject of the information is not authorized to immediately and directly receive his or her lab test results unless defined by state law. So again, you got to know your state laws. Access to the individual's clinical lab information occurs through the provider who orders the test. And this kind of goes all the way back to HIV. When HIV was really becoming a major concern, people would go get tested and then they want to get their results back, and they were asking anybody and everybody to get a copy of those, and the results were being sent to the doctor, and the doctor was supposed to sit down with the individual and talk with them about whether or not their results were positive or negative, and what did that mean, and what were next steps and all of that. So this rule has been around for ages. Insurance companies and government agencies, payment requests. If it's for payment purposes, including utilization review and medical necessity review, there is no requirement or patient authorization to obtain the PHI if the PHI being provided is for the payment of a specific episode of care. Otherwise, yes, insurance companies and government agencies do require patient authorization. But if it's for payment purposes, and that could include utilization review or medical necessity review, it does not. Medical emergencies. The obligation is to treat the patient and provide whatever information is necessary. This usually entails disclosing patient information without authorization, because again, there's the implied consent for treatment, and so information is to be shared at that time even without the patient's consent in order to provide them with the care that they need. All right, now let's get to public figures or celebrities, because this seems to be where everyone goes sideways and where there are major problems. When it comes to public figures and celebrities, their information is just as confidential and deserving of confidentiality as everybody else's. And the feds and the state are looking for healthcare organizations to make sure they have special procedures implemented to protect patient confidentiality, as well as lots and lots of audit trails and lots of audits being performed to validate that people are not inappropriately accessing the PHI of public figures and celebrities. So a couple of things. There's the directory where an individual can opt out, and general information is released only with an authorization. You can omit the name from the record, use a code name or alias. We had some of those. Again, computer access and paper record access restricted on a need-to-know basis, job related. Designated spokesperson is sometimes utilized to address the media questions. And staff training and non-disclosure statements are always a good idea, always need to be happening. Social Security Administration and State Disability Determination Services. Okay, so you have the federal and state governments looking at this information. To help defray costs and expedite the review process, there is an initiative that offers providers a secure electronic option for submitting records, and you can do that. When someone goes to Social Security Administration or State Disability Determination Services and they fill out the paperwork, this is when they're voluntarily authorizing the sending of their information and their records related to their case. Health information handlers, including payment integrity review contractors and health information exchanges. Okay. There are all sorts of what they call HIH, or health information handlers, that use information or PHI on behalf of a provider. They may be a covered entity or a business associate or a business associate subcontractor. They still have to follow all the HIPAA rules. If it falls under Medicare fee-for-service programs, those are not required to provide authorization for disclosure of PHI. So RACs, MACs, ZPICs, all of them, they don't have to get patient authorization. They just request what they want, and we have to provide it. Providers may respond to review contractors online through a new mechanism, and it gives it to you here so that you can deal with it instead of having to work through a large stack of paper. So how do we manage the release of information process? Well, first of all, the legal health record needs to be defined, and so does the designated record set. You need to answer the question in your policies and procedures, what to do with information from other sites, and who is responsible for disclosing information. There are all different types of requests, and this just lists them all. But you need to verify the requester and validate that the authorization is valid itself. You go through, review the authorization. Is it valid? Is it not valid? Depending on whether it's a mail request, a telephone request, a fax, internet request, a walk-in, an on-site, all those types of things, you gather the information and do that. So going back to, is the disclosure appropriate? Is it HIPAA or state law compliant? Exactly what content should be released based on the authorization, and what department should release the information. When it comes to subpoenas or court orders, we've talked quite a bit about that, so I'm not going to spend a whole lot of time here. And again, you have to know your state to know how to handle that. A court order is basically you have no choice. It must be turned over. Subpoenas without patient authorization in states where they are not equivalent to a court order have to have the patient authorization or a court order. We talked a little bit as we've gone through here about cost for ROI and reimbursement and that sort of thing. And I'm not going to touch on that here. I think your book is going to pick up a little bit of that. And that would be, let's see. Page 372, figure 15.3. So if you're interested, that would be where you'd go. I really like figure 15.4, so please take a look at that. And there's a nice flow chart on page 375, so that would be worth looking at as well. Accounting of disclosures and tracking releases. The privacy rule requires that the tracking and accounting of disclosures of PHI, as we talked about in Chapter 11, this requirement currently includes all disclosures made in writing, electronically, by telephone, and orally, but does have some exceptions. So if you're not sure about that, please go back and review Chapter 11 for those details. Patients have the right to request restrictions. So a patient can say, I don't want my information disclosed to this or that. So for instance, if someone decides they're going to pay for an emergency room visit out of pocket instead of using their insurance, they can request that the hospital or covered entity not release their PHI to the health plan for payment, but instead bill them and they'll pay it. So that is possible. Reasons for refusing to disclose information. Well, we talked a little bit about it. One of the first things is are we talking behavioral health, substance abuse, HIV, AIDS, those types of super sensitive types of PHI. So if you're talking about that, there are times when that cannot be released. And hopefully your organization will have policies and procedures that will specify when that is. But there are times when, yes, you do need to refuse to disclose the information. If the identity of the person that is presenting the authorization is in question. So for instance, if somebody shows up and they hand over an authorization and refuse to give you identification, or the authorization, the signature of the patient doesn't match the signature in the record, those types of things, you can refuse to disclose the information. If it was completed without the patient's knowledge or after the patient had signed the form, if you doubt the person requesting the information is really the person that's named in the authorization, if the person who signed the authorization is not of legal age, if you're questioning the competency of the person who signed the authorization, maybe you know they have dementia, and yet you're seeing this going on. Those are all examples of times when you need to refuse to disclose information, but I'd strongly recommend that you get your manager or director involved to help you through that minefield of a situation, which does occur. There are times when you truly can't release the, PHI to people, and hopefully you can explain it in a way that they understand that you're really trying to protect the PHI. That is it for Chapter 15. Sorry it ran so long. Hope you're doing well and have a great week.